be seated. Good afternoon. Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is 01-24-00702CV, Venable's Construction Company versus Aspen Midstream, LLC. Starting with appellant, counsel, will you please make your announcements?
Daniel Johnson for appellant Venable's Construction, also out of the court number. She's not participating in the argument.
Good afternoon. Appellees?
Natalie Arbaugh on behalf of Aspen Midstream, the appellee. And Dylan French.
Dylan French. Okay, thank you. Each side will have 20 minutes for argument. Does the appellant wish to reserve time for rebuttal?
Yes, Your Honor, 5 minutes.
Okay, 5 minutes will be reserved for the appellant. And before we begin, just some housekeeping matters. You have the timer in front of you. Of course, red means stop. When it's yellow, you have 1 minute left. If the light comes to a red and you're in the middle of answering your question, please feel free to finish your answer. We have read the briefs, so we are very familiar with the facts. We have reviewed to the extent, of our ability all of the contracts. I know there's many provisions here, but it would help us most if you just get right to the issues at heart, the issues on appeal. And with that, I think we're ready to hear from appellant.
May it please the court. We are here today for a construction issue pertaining to the construction of a pipeline. There's two fundamental issues, of which many of the ancillary issues relate to. The fundamental issues being Venable's affirmative claims and the counterclaim asserted by Aspen for the duty to defend. There's limited time. I'm going to attempt to address it all, but should the court have a question pertaining to the issue I'm not addressing that's more interesting than what I'm talking about, we'd be happy to oblige. We're in fact welcome to oblige the court to address those issues. First, for the affirmative claims, Aspen focuses on three main issues. One, whether the lump sum provisions of the contract encompass any and everything. Two, the change order provision. And three, the timing of the final invoice. The legal issues related to the interpretation of the contract as it pertains to these three items. For the aspect pertaining to the lump sum, Aspen contends that Part 4 of the contract, which pertains many important provisions addressing what is included in the scope of the capital W work, is an ancillary agreement buried in the agreement. This isn't the case. The very first section of the contract, Part 1, Section 1, defines what is the capital W work. It defines the capital W work in context of two documents. One document is Exhibit A to the contract. The second document is contractor's proposal, which is Part 4 of the contract. The Exhibit A, it includes a description of the scope of work at a high level. It discusses 298,509.29 linear feet of pipeline to be installed. It also includes a provision which provides that while minor deviations may happen in the route of the pipeline, to the extent of other deviations that affect the lineal quantities, then additional compensation may be owed to Venable.
So why doesn't the notwithstanding clause resolve this question, which says, notwithstanding anything to the contrary, contractor agrees that any changes in the amount of materials or work of any kind or character as described in A and B will not be extra work? Why doesn't that resolve this issue?
Why it doesn't resolve the issue, Your Honor, is because the definition of the inclusion of the unit prices and in Part 4 of the contract, which addresses what is within the capital W work, includes a defined quantity of 39 road bores. 39 road bores identified by name, length, and...
But why isn't that a change in material or work of any kind when you're still talking about point A to point B?
Well, the road bores can change dramatically in between point A and point B without a change in maybe I'm misunderstanding your question, Your Honor. From point A to point B, the road bores can change dramatically even if the overall length of the pipeline remains the same. But with respect to that provision which addresses what is extra work, Venable's position is that The contract specifically defines what are the quantities of bores included in the capital W work. And that was specifically what was bid on by the contractor. And the quantities of, this isn't a quantity change in a bore, or this isn't a quantity change, strike that. This is a change in the amount, a change in what was specifically defined to be the capital W work. In that it is, the 39 specific bores went from 9,844 feet to 14,000 feet. And in accordance with that provision, which provides that additional quantities shall be paid according to the unit rates contained within Part 4, Aspen provided an AFI form for items not included in the lump sum price. That form included a unit price of $352 in the Aspen provided form for additional road bores.
Why were there additional road bores? Just factually.
Reroutes. Reroutes to the property that were directed by Aspen. These were directed by Aspen with full knowledge of the fact that the contract included 8 pages of unit prices that must mean something in the contract. 8 pages of unit prices, which include prices for additional road bores. It also includes prices for things like saddlebags, bags that you put on the pipe to keep it from floating in the ditch, extra depth ditch, move-arounds, things of that nature. Aspen put these unit price items on its Exhibit DD, items not included in the lump sum form, and pursuant to that form, Venable's invoiced for over $2 million worth of unit price items, all of which were paid. All of which were paid based on their unit rates. Because these pipeline contracts, this pipeline contract isn't unique. There are many pipeline contracts like this. The lump sum is defined in the scope of what was known at the time. The Aspen's company representative admits that had he known there would be 14,000 feet, that would be what would be bid on.
Mr. Johnson, there's a provision in the contract, though, both in Part 1 and Part 4, where Venable assumes certain risk associated with extra linear footage, including under Section 1 in the second paragraph. I will only read the very long provision, but to some extent, Venable's agreed to take on certain risks that may impact the scope of work, and notwithstanding, the lump sum price would still apply. How do you reconcile your argument that this was work that should have been compensated when the lump sum provision and the contract states that Venable took on potentially that risk?
I would respond to that 2 ways, Your Honor. The first way is our interpretation of that provision you're referring to, Part 1, Section 2, is that it is in the context of what is specifically defined as the work. And so the risk that Venables undertook in that circumstance was, should its cost exceed its estimates to install the defined quantities, then Venable certainly was at risk of that. But what it wasn't at risk of was Aspen directed modifications to what the capital W work actually would be and how that would affect what Venables had to do in response to those directives.
Let me ask you this, in your view, is the work defined as getting from point A to point B, or is the work defined as the linear footage that is inclusive of getting from point A to point B?
In my view, Your Honor, the work is defined in 3 components. The 298,509.29 linear feet.
Can you just tell us where you're getting each of your components in the contract?
Yes, Your Honor.
Thank you.
So in Part 4 and Exhibit A both reference the length of the pipeline, which is 298,509.29.
Okay.
And there is a component, a small component of Venable's claim pertaining to the additional footages. Part 4 defines 39 bores by name, location, and length in the Part 4 of the contract. It says a specific road that Venables was to cross, and that is where we define the scope of work for what the bores would be. There is no dispute that Aspen directed additional changes to the bores, and that these changes were followed by Venables, and that's why additional bores were installed. And I do want to add one more thing to my response to your previous question, Your Honor. Even setting aside what the contract provides, there's also an issue pertaining to the party's course of conduct on this project. Consistent with the contract provisions I just described and the AFI form that specifically provides that these unit price items are not included in the lump sum, Venable's invoice and Aspen paid over $2 million of unit price items.
There's no doubt there's signs of departures through course of conduct, but where does that lead? I mean, if it's right, do you go try it up as ambiguous, or what do you do with that?
Where it leads is at the very least, Your Honor, at the very least, there is a question of fact that must be tried on this issue.
What would you ask the jury?
What we'd ask the jury is to find that, consistent with the course of conduct and the agreement between the parties about how Venables would be compensated, Venables should be compensated in accordance with that
I
course of
mean,
conduct.
literally, what would the words of the question be to the jury?
To the jury, the question would be...
Yeah, your liability question, what's it going to say?
It's going to say that there is and this is assuming that the contractual argument. We're not responding to the contractual argument, but to the other argument. Was there a separate agreement entered into between Venables and Aspen, separate from the contract pertaining to the additional bores?
My last question on this half of the case then is, if you'd care to comment on the El Paso versus Mastec.
Yes, absolutely, Your Honor. El Paso versus Mastec, the contract in that case is fundamentally different from the contract in this case. There are no unit prices provided in the El Paso contract.
If there were, would it be controlled?
If there were unit prices in the El Paso contract, I don't recall there being any discussion of how those unit prices would be applied in that contract. I do agree that a contractor can agree to a lump sum price for a defined scope of work, and there's also language that you can use to establish that. Our position is that that language was not, every time the word lump sum is used in this contract, it is expressly in the context of what is defined as the capital W work, which is only defined in the context of Part 4.
I have a question about the other issue.
Yes.
The judgment says the court orders Venables has a duty to defend A&P in the Woods litigation.
Yes.
What does that mean, and how is your life better or worse because of that declaration?
What that means is the court has determined that the duty to defend does in fact exist.
And therefore, whose rights are different today, tomorrow, the next day? What are you going to do any different? What are they going to do any different because of that declaration?
Well, presumably at the conclusion of the Woods litigation, Venables will be sued for the defense costs that Aspen has been, A&P has been incurring.
As indemnity, they want indemnification for that at the end. They've reserved that right, correct?
They've reserved the right to indemnification.
So how does this declaration alter anybody's situation, one way or the other?
Well,
they're defending, right?
Correct. Well, at the time that Venables is sued for indemnification of the defense costs, Venables would intend to defend itself that the defense obligation is void under the TIA, that it had no defense obligation, and this judge would have already declared that was rejected.
How is that right now? How is that issue right for our review?
Well, our position is that the judge has issued a final judgment on the issue that Venables does in fact have a duty to defend.
But okay, separate indemnification from duty to defend.
Right.
They have not asked you at this point to defend, correct?
There has been, it's not in the record, subsequent to all this briefing, a tender.
They have asked you, but it's not before us.
Correct.
Okay.
That was after the trial court entered its summary judgment
Correct.
orders. Prior to that, the defense had not been tendered, and therefore has Venables actually denied taking on the defense prior to the motions for summary judgment being presented and ruled on by the trial court.
Has Venables denied prior to the summary judgment? Am I understanding the question?
Yeah, let me ask it better. Before the trial court entered its final judgment, on review now, had Venables denied any tender of defense?
Venables had not denied a tender of defense. Venables denied it had an obligation, but it has not denied a tender prior to the issuance of the orders.
You can see where we're going with this.
Yeah. Let me ask you, do you agree that reimbursement of defense costs is an indemnity issue, and it does not fall under the right to defend, under the indemnity provision?
I don't know if, I'm not exactly certain about the answer to that question, Your Honor, but what I would say is, what our concern is how those issues become mixed with how the duty to defend, which we believe does not exist, and has been adjudicated to say it does in fact exist as to Venables, that is the issue that is untenable to my client.
Right, what you said a minute ago sounded pretty reasonable to me, that what you're worried about is at the end, you're gonna get a bill, they're gonna say, here, pay all of this that accumulated, because you promised to indemnify us to pay for this, that we've been defending. And I heard you say that, which sounds right. I just don't see that it's necessarily before us today, and I don't see that it was before the trial court.
Yeah, help us understand that. Why was it not before the trial court, or why was it before the trial court?
The duty to defend?
Yes, but when they had not yet asked you to defend, but had, per the contract, exercised their option to defend themselves. So separate indemnification.
Right.
Why was the duty to defend right for the trial court to review or not?
These are not meant as hostile questions.
Correct.
They're
Yeah,
gonna be a little more
we're
hostile
trying to
in a
figure it
minute.
out.
But,
Yes.
but we want to talk about, because jurisdiction's not waivable, we're just trying to figure out, have we got something that we can actually get our teeth into?
Right. And my response to that is, it goes back to what you were just referring to, Justice. If we get to the point where there is a demand and we did not appeal this issue,
You don't want like a law of the case or a
correct
preclusion
law of
problem.
the case, and now getting to whether the trial court ever should have addressed it. That issue did not arise in the trial court level. Aspen demanded indemnity and a duty to defend, a declaration of both, amended its counterclaim, the second amended counterclaim in September of 2023 to drop the indemnity count, but persisted in the duty to defend count. And now the trial judge has issued an order that my client perceives is applicable to it in any proceeding moving forward. So our concern is how that could be construed against us, because we believe it's fundamentally wrong for 4 separate reasons.
My crystal ball isn't working great today, but I suspect we'll come back to this. I think it'll come up again.
Thank you.
Thank you,
Any
Your
other
Honor.
questions?
Thank you, thank you.
Thank you. We're ready to hear from you, Ms. Arba.
Thank you, may it please the court. This case is about a contractor, Appellant Venables, who's attempting to escape clear and unambiguous language of a lump sum contract, not a unit pricing contract, not a cost plus contract, a lump sum contract, where they explicitly and unambiguously assumed the risk under the agreement, which Justice Rivas-Malloy, you touched upon. A threshold issue for this court that I think is important is you must determine whether the contract's unambiguous. Relevant to that issue is not extrinsic evidence and not course of performance, because it's unambiguous, and in construing a contract to determine whether it's unambiguous, Texas Supreme Court has been very clear that extrinsic evidence should not be considered, and that includes course of performance. Even the cases they cite are where there were ambiguous agreements that were discussing course of performance. So none of the evidence outside of the 4 corners is really relevant to this threshold issue. So that's the first point. I also think it's really important to just see the forest through the trees by setting up for the court 3 basic structural aspects of this agreement I think are important to keep in mind in answering all of the questions that you all have asked and will probably ask of me. These are the 3 components. And the reason I want to focus on these is, as you know, your job is to construe the contract as a whole, not to look at provisions in isolation from one another. So I think you have to think about this structure when you're construing the contract as a whole. So the first point is what's been, I'm not going to belabor, but it's been in the briefing. This is a lump sum agreement. That's clear from Section 5, Part 1 of the agreement, where it mentions the lump sum price. It's not to be exceeded under any circumstances. That's clear from 6J, where it says it's a total and absolute cap, regardless of all these other things that might happen. That's clear from even Part 4 that they rely on, that discusses unit pricing, that ad nauseum refers to the lump price. So the lump price nature of this agreement, as you all know, there are all kinds of construction contracts. Sometimes there's lump sum, sometimes there's cost plus. This is no doubt a lump sum agreement. So that's important to keep in mind. The second aspect I think is important to keep in mind is the risk assumption, which again, you touched on, Your Honor. And this is important. The parties really didn't spend a ton of time in their briefing on that issue, but as you noted, in a couple of lengthy provisions in the agreement. That's section 1, you've already talked about that, and part 2, section 6 of the agreement. It sets forth in detail that it shall be the responsibility of the contractor, the appellant, to fully inspect and diligence the project to confirm the nature and the scope and anything that may affect the cost. That's clear. They made representations and warranties in that regard, further in the agreement in section 6J, and they even provided a signed certificate of due diligence that they did all those things, which is signed by their operation manager. The risk assumption, of course, goes hand in hand with the lump sum nature of the agreement, which is the El Paso case, Your Honor. And that's really important to keep in mind when we're talking about things that allegedly deviate from quantity in the original scope of work. And that, go ahead.
No, you're number 3.
Okay, number 3, sorry. The concept of work and extra work. There's 2 types of work, 2 types. The work is defined in the scope, which I'll get to in a minute, but they say this is not the work. The extra work is talked about in section 11 and when it comes to unit pricing, but they say section 11 doesn't apply. This is not extra work. They're trying to live in this alternate universe in the agreement that doesn't exist, a third type of work. There is not a third type of work that says, well, if it's this type of work, you must pay us for this type of work and this is how. That just doesn't exist in the agreement, but that is what they're asking you to write into the agreement.
Where does the subpart B special unit price and the AFIs that were in fact submitted and paid for the special unit price fit into the grand scheme of things?
Yes,
If there is a lump sum, but there was some payment under the special unit price that was made under the contract, maybe that goes to course and conduct, but in us construing subpart B, the special provision in part 4, how does that all fit into the puzzle?
Absolutely, Your Honor. So the AFI that refers to it that way should not be considered by the court in determining whether the contract is unambiguous. That's what the Texas law makes very clear. That's for a reason, because, you know, whether it's emails or other things, the courts in Texas law want to interpret the contract as they're written.
I agree with you.
Okay.
So let's scratch the AFI.
So that's for
we still have part 4, subpart B.
Yes, and let me just make one note too. The AFI never contained the additional bores, base lay, et cetera. They're trying to seek payment for here, just to make that clear. That's undisputed in the record. So what I think unit pricing comes in is extra work, because it's very clear both in part 4, subpart B of part 4, as well as section 11, that the unit pricing is for extra work. That's, to me, 100% clear. Now, having said that, as I believe counsel alluded to, and as I'm sure you all are familiar, when it comes to contractors and construction on the job, they can always agree in writing to do something differently, right? That's within the discretion of the owner who is enlisting the contractor, if that comes up. But in the context of this agreement, it's clear that unit prices are for extra work, and it's clear.
To make sure there's no superfluous contract language, what is extra work? What does that look like?
Oh, so as for an example?
Yes.
Okay. So I think of extra work as almost a totally different project. That's how I think of extra work, because when you read the language at the beginning that talks about it, it says it's outside and independent or not otherwise included in the agreement. I think when you couple that with a major change or deviation or a material change or deviation, it's getting at the notion that it's just a different project.
What is a major change?
The only way I know how to answer that is not what we have here. Because here what we had, just, you know, the other thing that comes up in construction contracts is little things come up all the time, right? Because third-party permits, landowners have issues, things like that, right? And so then the contractor, in this case Venables, would come to us and say, hey, we've got this issue. Or we would come to them and say, hey, we've got this issue, how do we want to resolve it? And it's like, okay, well, let's go around this route and do it this way, right? And we would approve that. We wouldn't necessarily direct everything, but we would approve that. That's all in the course of the work, the way the work is defined.
Mr. Johnson says the work was defined by the specific number of bores. Can you address that?
Yeah, I just disagree, because the way, I'm going to come back to the definitions in a minute, But the way the scope of work is defined is to install a 30-foot 30-inch natural, that would be a big task.
Yeah.
A 30-inch natural gas pipeline between Aspen's Lobster site and Washington County and its receiver site. So it's a 30-inch pipeline going from point A to B. So, you know, the parties put in some dimensions and things they expected, but for example, on the linear footage measurement he mentioned and the boring he mentioned, all of those things are listed both in Part 4 of the agreement and in when the scope is being discussed as approximately, which says something about the way people are looking at the scope of this work. This is a lump sum agreement. We know there's going to be minor things and quantity changes here or there that come up, but you're assuming the risk of that. That's why we're letting you diligence the project, because you've done this enough times, you're a sophisticated party, you know the things that you need to account for in this project, and that's a part of the lump sum.
And the notwithstanding clause says changes in amount of materials or work of any kind. I mean, it covers that.
Yes, and if I may add to this, and we talked about the definition of work in our briefing, but there's one part of the definition of work we didn't focus on as much. There's actually three things that sort of compound the definition of work here that show how broad it is. There's section 1 of the agreement that says the work covered by the lump sum includes all items necessary to complete the work described in Exhibit A. Then Exhibit A, when discussing the scope of work, aside from describing it the way I've described, getting from point A to B, all activities necessary to complete installation of the 30-inch ACE pipeline. All activities necessary. Then there's another definition in Part 2, and this the parties didn't spend a lot of time on, but it goes on and says, as well as any other additional things as may be necessary to achieve the intent of this agreement in a timely manner. I think it's clear the parties are saying, here's this project, here's the scope, and it's the scope of the work is broad, and your lump sum is supposed to account for that.
Can I take you, if okay with you two, to the second issue? Can you help us understand how the not indemnification issue, but the duty to defend issue was right before the trial court at the time if you had never made a demand for defense?
So I have to say that in preparing for this argument, reading the briefing and the case law, I think that they have the better side of the argument that we did not tender a defense before the court ruled on it. So I want to answer that question first. There's the way that we thought about it is there's the tendering of defense and advancing the costs of the defense. And so when we made our claim, we looked at it like we want to have a declaratory judgment that's a right we have under the contract. We dropped the indemnity portion. Your questions were all made sense on the indemnity. That's for a later date. But we were thinking about advancements of costs when we pursued this claim because we wanted to make it clear that we were not foreclosing that duty. But I do agree with you that it was not tendered the way it should be prior to the court ruling on it.
So what are the implications of that on the issue that is pending before a court based on that concession?
I think it is tricky for the court because we do have a DJ on it, and I think it depends on what you do on the other issues and whether the case is live, because we did send a tender after this, after the briefing. And so I think because of that, if you were to, for example, reverse and send it back to the court for ongoing proceedings, we've now tendered.
Can I ask about the decision tree then?
Yes.
Let's come at this holistically. There's a lot of different ways to approach it because that's one clash point. But there's the statute. I like getting organized to know if we decide this way on this issue, do we reach this one or how does that affect it? So if you tell us a little bit about, give us your argument on the statute if you don't mind.
Sure. Switched my brain gears here. So I think that's a tricky issue from the standpoint that no case has directly addressed the issue on the facts here.
Not a lot of case law.
And the Texas Supreme Court did not squarely address it, and that's like
in signature.
They did not squarely address the issue here, and I think they in no way, shape, or form indicated they were trying to completely undermine the body of case law that exists on the duty to defend. That is, that you construe the complaint and the allegations liberally in favor of it, and you have a duty to defend even if only some of the claims are covered. And that case is different than ours because the language in the agreement, the indemnity agreement itself, showed that they were putting the indemnitor on the hook for indemnity, even in the case of the fault of the indemnity. Our language clearly doesn't do it, so it just doesn't answer the question, and I don't think the Texas Supreme Court not only squarely addressed it, but it's just completely different facts. So you are, in a sense, other than unpublished decisions in federal courts, left with an open slate there. But I think the reality is you're pitting, we're pitting the issue of the duty to defend generally and construing the proceedings broadly, and even if it's only some of the claims, against the Texas Anti-Indemnity Act. And that's the question that has to be answered. And I think here, what weighs in favor of our position is the contract in no uncertain terms does not attempt to do that. And so for that reason, on this issue, we think we're right, even though it is an issue of first impression.
Well, then is it following that same chain of thought, is it really then, we're not really analyzing whether the anti-indemnity provision applies, because as written, the provision would implicitly comply with that provision. But it's a question of whether the indemnity provision is triggered at all, given the allegations in the Woods litigation. In other words, because it's AMP that is named in that litigation, the only question is whether the indemnity provision is triggered and not whether it runs afoul of the anti-indemnity provision.
I think it's both have to be answered if you go there, because the first question, to your point, is you have to determine whether it's triggered. It is triggered here, whether it's just naming AMP or not, because of the allegations in the complaint. And
but
because
if we don't agree with you that we can look beyond the 8 corners,
yes,
how is it triggered?
So you've got the Woods petition, which names the conduct, the facts that give rise to it. Some of those facts, when you compare those facts and
the failure to do the double ditching,
all that stuff, exactly.
and you're going to say that's got to be their fault.
Right, and
But how does that come up in the 8 corners? If you don't go beyond these documents, how would you ever know that they were involved in any way?
Yes, Your Honor. The indemnity agreement is actually in the construction contract, which shows that they were responsible for the double ditching. And we've cited those provisions in our briefing, Your Honor. So I don't actually think you have to look outside the 4 corners, and I don't think you need to go to the Monroe factors. Because the indemnity, unlike many situations, it's right in the very agreement that shows they were responsible for that. And so putting those things together,
that answers a part of the equation.
Yes.
They might have been responsible.
Yes.
So may have AMP in its easement agreements or in the torts are related to. So when we have these mixed parties involved,
that's when it's not tricky on whether to defend. It's tricky on the TAIA
right.
issue. On the whether to defend, if it potentially triggers
There's any way to
indemnity.
read it.
Right.
Just like
Right.
in insurance
Right.
cases.
Exactly. And even if it's just some of the claims, right? And the theories don't matter, the fact that only AMP, none of that matters. It's
Right.
really the facts. But then, and so if you determine it's not triggered, whether under the 8 corners or under the Monroe factors, you don't need to get into the Anti-Indemnity Act. But if you determine it is triggered, then it makes sense to get into the Anti-Indemnity Act and engage in writing some law for state.
If you don't mind commenting, I know it won't be in the record, where is the Woods case in the trajectory of life, and what mischief is Tom Zabel inflicting now?
Well, it's coming up for a mediation, so I'm not exactly sure where it is in the rest of it. I just came into this.
Fair enough.
Can you help us understand, coming back to this issue with, I understand now you've made a request for defense, but the way I read the contract, it says at any time you can opt to defend yourself, or you can tell them to defend. So
Yes.
I was thinking about, okay, what if tomorrow you made a demand that they defend? How does that affect whether the declaratory judgment issue was ripe or not? The fact that you could have made that request, and in fact now we know you did.
Mm-hmm.
Does that change anything for our decision?
I do think it potentially does, again, depending on what you do on the motion for summary judgment. If you affirm the motion for summary judgment, then that's a different issue than if you reverse, because if you reverse, it's now this case that's ongoing. And so we could right? We could still want that right in an ongoing way. If the case becomes a final judgment, it's settled on appeal, and we're just left with indemnification. So I really think it depends on what happens with the other issues.
Can you walk us through both ways?
So if you affirm the motion for summary judgment, and the denial of appellant's motion for summary judgment, which means all liability is in our favor, then the matter is going to get closed, right, presumably. And therefore, we end the case with a final judgment, and I think the defense issue now becomes an indemnity issue.
Right.
If you reverse it and you say, trial court, this case needs to go forward, that puts us in a different posture, whether you reverse it on theirs or you reverse it on ours, because now we have a case that's proceeding past the final judgment stage clearly, and we could ask for a tender of defense or advancement of costs at that stage.
Have you, at the time that the motion for summary judgment was decided, I know that you had assumed the defense. Had the tender of costs been made at all? Advance costs for attorney's fees?
Not advancement in the context of our indemnity request.
Right.
How is that not just indemnity? How defending is defending. How is a request for the cost to defend not just a question of indemnity?
So on the tender question, the way we tendered originally, it is just indemnity. The duty of defense can include the advancement of costs beforehand. And so that's how it's not indemnity.
Where does it say that in the provision? Because I read that a little bit different in this provision.
Oh, I'm sorry, Your Honor. I was actually thinking of Texas case law, and I don't have a case.
Not the actual indemnity
Yes,
provision.
yes, Your Honor.
Okay, thank you.
I only have 48 seconds left, and I don't feel like I need to say anymore. Hopefully I answered all of your questions. Thank you very much.
Thank you.
Thank you.
I'd like to address just a few things that I just heard. One is concerning the 8 corners issue. The contract says absolutely nothing about the Woods property. It does not exist in the contract. The Woods property, only work that was ever done on the Woods property was a result of one of these reroutes that we've been talking about. There is absolutely nothing in any of the 8 corners that ties Venables to the Woods property at all. The project was rerouted. And speaking of
Is the type of work that was done at issue, though, clear in the 8 corners that it was done by your client?
That there would be double ditching type work to be performed is in the agreement, correct.
But is it clear that it would be only your client performing that work?
No, it's not clear that only Venables will be performing that work, and that's not what Woods alleges either. And that's our point about the 8 corners rule. But the reroutes segue perfectly into the next thing I wanted to say to you, which is the focus on the Venable's ability to go do due diligence on what was to be included in the project. That pertains to the defined scope of work. And Aspen has not addressed how the lump sum price and special unit prices are divided into 2 parts, subpart A and subpart B. The importance of that is the additional bores, which is the heart and soul of this case, were the result of reroutes and changes that were made by Aspen with unit prices in the contract subsequent to the contract being signed.
Why were they major changes?
The contract does not define minor and major changes. However, the number of bores went from 9,844 feet to 14,000 feet. And bores are one of the most expensive things that can occur on a construction project. So from the level of expense...
What in the contract says they assume that risk? Because there is a lot of language about you assuming risk.
What in the contract says they assume the risk is that the contract provides that for the purposes of payment, companies shall measure the quantity of each unit of work completed and pay the contractor at the unit prices. That must mean something.
That's only for extra work, though, so we have to agree that this is extra beyond the work.
Right, but to contest that extra work is a different project makes no sense in the context of the contract specifically saying that extra work can be in the form of these things that are included in unit prices.
Mr. Johnson, I think that goes to a point that Ms. Arbaugh made, and it's in the briefing as well, that there is this middle ground that at some point it seems like Venable is arguing that the extra work provisions at subpart B, part 4 apply, but at the same time it's arguing that this is not extra work, that it's part of the work for which it should be compensated. So it does seem that we're vacillating in this middle ground between work and extra work. So is it extra work that Venable wants to be compensated, or is it work as defined work where the unit price items would apply? Which is it?
That's a very good question. So our position is that the change order provision doesn't apply because it isn't definitionally extra work according to how you construe this contract as a whole.
So if it's not extra work, then we don't need to work about the extra work provisions in the contracts.
It's not definitionally extra work because extra work is something which does require a change order.
So if it's not extra work, then what do you do about the lump sum provision and the absolute cap provision and the notwithstanding clause about the compensation for work?
It's not extra work in the sense of how the contract defines extra work, but it is work that is outside of the scope of the capital W work. So the distinction I'm drawing is capital E, capital W, extra work, which is a defined term in the contract, and additional work. In my
But where
opinion,
does the contract allow this third category of work?
the contract allows it in the definition of how the work is defined and the fact that additional unit prices will be paid based on the additional quantities.
Can I take you to a different issue
Yes.
very quickly? In light of their concession or agreement with you that they never made any demand for defense for the summary judgment, what is your position on what we should do with this?
Well, I don't think that the declaration that Venables has a duty to defend can stand in its current form, because if the case, like counsel said, if Aspen were to prevail and the case is closed, with that being the law of the case, then I don't think that can stand. But it can be reversed for other
setting
reasons.
aside the eight corners rule, setting aside the merits, I'm asking in terms of the rightness of the issue before the
Right.
trial court. Is it your position that if the issue was not right, and so we should send it back on that basis?
Your Honor, I hadn't thought of this issue this way before, so I'm trying to think of it now. My first response to that would be, it would possibly be something that might be better suited by a letter brief if the court wants it, but my position, just standing here right here today, is that we think it is right to be decided.
Decided by us?
Yes.
But by the trial court too?
Well,
I'm not trying to put you on the spot. You're welcome to send a brief later.
Yeah, and we'll go talk about it. We may even ask for one.
Right.
On this to make sure everybody gets fully heard.
I'm not embarrassed to say, maybe I should be, that I hadn't thought of it from that angle before, Your Honor, and it's an interesting question.
Well, don't be embarrassed, both
You
of
don't
you.
have crystal
First-rate
balls.
lawyer,
Yeah,
and
crystal
good
balls.
arguments, good briefing. It makes our job really a pleasure. Thank you both.
Yeah, thank you both sides for your arguments today. We appreciate it. This case is now submitted and we are now adjourned.
Thank you.